Hello, everyone. Welcome to Challenges for Copyright Reform in Brazil, a project that seeks to discuss how a copyright regime can balance access to content in a digital society with the conditions to economic exploitation of protected work. I'm Alexandre Pacheco da Silva. I'm a law professor at São Paulo Law School at Getúlio Vargas Foundation and the coordinator of the Center for Education and Research in Innovation. Today, our guest is Professor Michael Geist, who has very generously accepted our invitation. Professor Geist is an internationally renowned copyright law scholar, and currently he teaches law at the University of Ottawa, where he holds the Canada Research Chair in Internet and E-commerce and serves as a member of the Center for Law, Technology, and Society. He has also authored a great number of well-read works on Canadian copyright law. He's an editor to several monthly technology law publications, and last but not least, authors a popular blog on internet and intellectual property issues. Professor, thank you very much for being with us today.
Oh, thank you so much for having me. It's a pleasure.
And also for this interview, I have the presence of two talented researchers that will present questions for Professor Geist. The first one is Vitor Doering da Silveira. He is a senior researcher and a PhD candidate in law at the University of São Paulo. And we also have here with us Tatiane Guimarães. She is a full-time researcher at série and a LLM candidate at Getúlio Vargas Foundation's São Paulo Law School. Together, they lead série's ongoing research project on copyright reform for the digital age. So, Professor, my first question for you deals with exceptions and limitations in a copyright regime. Copyright exceptions and limitations are a key aspect of current debates on copyright reform. I would say a key element to our discussions here in Brazil. And one thing that we discuss here is a perspective that deals with different jurisdictions and different approaches. While some jurisdictions, such as the United States, seems to evaluate the legality of uses of protected work without owners' authorizations based on case law constructions, such as fair use doctrine, and other ones, such as Brazil, prefer to establish copyright limitations in their positive law. We can say that we discuss a lot what type of approach has more advantages than disadvantages. And we would say that the degrees of legal security regarding the proposals that we are discussing currently need to be adaptable for technological changes. We discuss a lot of these things in Brazil. So my question is, generally speaking, do you believe that lawmakers should establish strict rules for copyright limitations and exceptions, or they are better off leaving them to be constructed by case law?
Okay, that's a great first question, and I certainly agree with you that the emphasis right now on how we strike the balance, and that often involves a debate on limitations and exceptions, has been really for quite some time now, and certainly is still today one of the real core issues that I think a lot of countries are grappling with. In Canada, just to give you a perspective on Canada before I give you the broader answer, we've actually have Supreme Court jurisprudence that treats limitations and exceptions as users' rights, and our highest court has emphasized that copyright is fundamentally about a balance, striking a balance in the public interest. Public interest best served through a balance where we think both about appropriate protection for creators and at the same time appropriate levels of access for users, as well as reuse of some of those same kinds of works. And so they have fashioned our fair dealing limitations and exception, which would be the sort of similar to a U.S. fair use, in light of or thinking about a user's right. And I think that's had a pretty profound effect in terms of how we think about some of these exceptions. I can get into it in further detail if you like. But that Canadian experience is in some ways instructive to your question, because the statute doesn't speak of user rights and also doesn't necessarily provide the full guidance for how to interpret some of these rules. And so it has fallen to the courts to provide an appropriate test and interpretation for how we deal with fair dealing in our context. And that has allowed, I think, courts to adapt their thinking to the current environment, technological change, to some of the new kinds of uses, as they continue to try to ensure that there is that appropriate balance. Now, this choice of should it be contained in positive law or should we leave it to the courts, I actually don't think we have to make a choice of one or the other. I think in many jurisdictions, we find that it's a bit of a hybrid. And I think that would be true for us as well, where we get through the statutes the broad outlines of what fair dealing constitutes, with the statute stating that fair dealing will apply and will allow people to use other works without permission of the rights holder in certain circumstances, and then identifying, at least in Canada, the purposes for which those uses can take place. Now, in some ways, the law really, there are in some ways two key elements here. One, what is the purpose for which you're looking to make use of this work? And then two, under what circumstances is something going to be considered fair? I think flexibility is good, frankly, on both counts. In Canada, we have less flexibility with respect to the first test. So our law does identify the various purposes that will apply. The government has expanded those purposes in recent years, and the court has said it should be a very low threshold to qualify. And so that decision, that low threshold, I think has been important because it's allowed courts to take a broad interpretation of the various purposes. Nevertheless, it is still constrained by the statute. What will constitute fair dealing, though, when will this apply, assuming you apply for a purpose, has been left to the courts. And it is the courts that have set out the test, and it is the courts that will ultimately provide that interpretation. I think we could do better by adding more flexibility on the first part of this issue, because I think what really matters is whether it's fair or not when we start thinking about the dealing, not the purpose itself. But nevertheless, given the low threshold, we find that it comes close, if not fully the same as fair use.
My question for you is this. Around 20 years ago, there seemed to be a generally broad understanding, a generally broad consensus internationally that internet intermediaries should be treated as generally non-liable for damages caused by illicit content which was produced or shared by their users. This, of course, led to so-called safe harbor provisions and notice and takedown. Of course, you have different arrangements, different ways in which you deal with that. In Canada, you have notice and notice. In Brazil, you have a somewhat different regime, which we will not get into the specifics right now. But you can say that generally, notice and takedown and safe harbor provisions are basically at the heart of the traditional consensus on intermediary liability. For the last 10 years, however, copyright owners have increasingly pressured for stricter liability regimes, pushing intermediaries into imposing tougher terms of use regarding copyright compliance and fighting digital piracy. My question is this: do you believe that safe harbor provisions require reform to better protect copyrights? And if so, what updates would be the most needed? Do we need, in other words, do we need to reform notice and takedown? Yes or no? And if so, how?
Okay, awesome question, and clearly a really difficult one in the sense of one of the core issues that I think has captured attention in countries around the world. I think I'd start by answering the question by saying that I think it's difficult to think of this issue at this moment solely within the context of copyright. There's no doubt that much of the debate around the role of the large intermediaries or large platforms started in sort of from a copyright perspective. And generally, I think it's fair to say that the view, certainly influenced by US law in particular, was that you'd have a set of rules for copyright. In the US, it was notice and takedown. As you mentioned, in Canada, we have a notice and notice system. But then you would also have a set of rules with respect to much of the other content that exists that is posted to platforms. That's where the US's CDA Section 230 sub C provision comes in, which has created an important safe harbor for many of those platforms. I think it's fair to say that there is a considerable amount of debate about both of those systems, and in some ways, at least over the last couple of years, especially given concerns around misinformation and online harms, the copyright debate has actually taken a bit of a backseat to the broader issue of the role of the platform. So we're seeing, I think, much more in the way of discussion about what is the, there are dials, in a sense, policy dials, as Daphne Keller at Stanford likes to say, that we can maneuver in terms of trying to address the appropriate standard for platforms. We're seeing a lot of pressure to make changes to how we dial up the liability. Much of that is being driven by the concerns around misinformation, and then of course the implications for freedom of expression. So thinking about this, primarily from a copyright law perspective, is more challenging in some ways now than it's been in some time, because while once it was copyright that was in some ways kind of out front in terms of trying to ascribe greater liability, I think it's now taken a bit of a back seat, at least in the minds of policymakers and politicians, as their focus is certainly been heightened when it comes to platform liability or intermediary liability, but it's now today, I think, less about the copyright related issues. If we were to continue, though, to sort of think about, well, where does the appropriate balance lie? I think certainly in the broad sense, when it comes to platforms, I think we're going to see each country individually come up with some of its own balance. And so that question of where do you place the dials is, I think, going to differ between different jurisdictions. We've seen some, especially when thinking about online harms, that have emphasized to a significant degree greater liability, hopefully recognizing that there is a cost to be paid for that. There are benefits, to be sure, but there's a cost to be paid in terms of freedom of expression, over blocking or over removal of content. And when there are others that will say, no, we've got, let's say in the United States, we've got First Amendment rights, and so those are going to continue to apply, and we've got to keep those in mind. In Canada, we're actively having this kind of debate, and it's a challenge without question to ensure that we consider what in Canada is our Charter of Rights and Freedoms, that to ensure those are preserved while at the same time dealing with some of the other issues. And I know that we haven't yet landed on the issue. I guess the one point of commonality, though, that I think exists between these two regimes, in a sense, between copyright and online harms, and where the platforms sit, from my perspective, would be due process. And so if you don't set up a system that ensures effective due process, where there are claims, whether claims of copyright infringement or claims of online harms, I think you run the risk of having a significant negative impact on freedom of expression and some of the sort of the core freedoms that I think many of us treasure generally, and then in particular online. So I think I see that first with respect to misinformation issues. We've seen a lot of emphasis on taking content down quickly. The NetzDG law coming out of Germany, for example, taking that down, within some content down based on a claim within 24 hours. There are big risks there where content comes down that may be perfectly legal content. Sometimes it may be so-called lawful but awful speech. So we don't like it so much, but it's still legal. And so if there is a bias towards takedowns because the emphasis is on doing it quickly rather than doing it right, I think there's real risks there. And I think you need a due process system to help ensure that those issues get addressed. I think that remains the case when it comes to copyright as well. The choice that Canada made with respect to a notice and notice system, the system that we see Chile having adopted, I think has recognized exactly that concern, that in a notice and takedown system like you find in the United States, it is so-called shoot first and aim later. Content comes down, there is no real due process before it comes down. It's kind of dealt with after the fact, where there is the ability to seek a putback mechanism, but many don't take advantage of that. The Canadian system was in some ways grounded in that concern. And so said we want to find ways to address copyright concerns. That's where the notice and notice side comes up. Excuse me. But what we also want to do is where there is a permanence of takedown, we want to ensure that there is appropriate due process and courts or court-like systems, tribunals or otherwise, that create that due process, from my perspective, becomes essential. So we've seen sort of this issue really blossom and expand well beyond copyright. But I think interestingly, at least one of the first principles that I think we ought to be thinking about in all of these circumstances is what is the due process system that we put in place to ensure that all the various rights, both expression rights and some of the privacy rights, copyright rights, and rights, I guess, to avoid the online harms, are all factored into the analysis.
Now, for your third question, we're going to focus on the European Union's Directive 2019/790. So among the many jurisdictions that have experienced copyright reforms in the latest years, one of the most discussed is this directive, which was passed with an explicit mandate of imposing stricter regulations, on websites with the goal of fighting digital piracy more efficiently. One of the most controversial dispositions, the Article 17, tasks service providers that host user-generated content to employ effective and proportionate measures to prevent users from violating copyright, which digital rights activists have pointed out as a violation of safe harbors provisions. So the question is, what is your view on the recent European copyright reform, and how does it fare in comparison with other international trends in copyright reform, which you are familiar with?
Yeah, another good question. I was concerned about where Europe was headed throughout that debate and remain concerned about where they landed. I think that process was in many respects overrun by a handful of lobbying groups representing largely the content industry, and they largely got what they wanted, I think, over the objections of frankly many citizens within Europe who spoke out loudly, but ultimately just were unable to match some of the inside lobbying and pressure that took place. And when you look at some of the rules that came out of that, particularly with respect to things like upload filters, and the increase in liability, I think it's quite clear that it was out of step with where many other jurisdictions were at. I assume that supporters in Europe would say that's a feature, not a bug. They felt that what they were looking to do was to create a higher level of liability, a greater level of responsibility, and hope that would prove to be a model for other jurisdictions. That we've seen that playbook out of Europe before, of course. In privacy, data protection would be a really good example of that, when we see it first with the directive and more recently with the GDPR. And we've seen many countries use Europe as a model. And I think the strategy from the lobby groups, and the strategy certainly from supporters within Europe, was not to be in step with or consistent with what we see in other jurisdictions, but quite the opposite, to actually try to advance from their perspective where they wanted to go. We haven't seen as many countries since, at least it's still early days, admittedly, but we haven't seen as many countries adopt some of those standards. And I think one of the reasons, at least for the moment, is that it oversteps. And when you move into a world of upload filters, of essentially putting the default to say we're going to try to remove content before it ever goes up, the impact on expression can be enormous. And so there is a reason that there are those kinds of concerns. The other aspect, and we see this play out on a number of European policies, is that there is, I think, globally a lot of frustration with the very large platforms, with the Googles and Facebooks of the world. And I think when we look at these issues from a privacy perspective and from a competition perspective, there's good reason in many instances for some of those kinds of concerns. And the fact that there is greater scrutiny of these companies and this sector, I think, is welcomed by really everybody, or ought to be welcomed by everybody, as a positive step to developing more effective and appropriate frameworks. The concern that at times, though, I have, though, is that Europe has seemingly been so singularly focused on a handful of companies that there's a great risk that ultimately some of the rules that they establish will actually enhance the power of those companies, not lessen it. So where you create regulatory or legal requirements that establish, whether it's content moderation requirements or certain filtering requirements, a range of different, what can be quite expensive and onerous obligations, the reality is that only a small number of very large companies can typically fully comply with those rules. And what you do, I think, is have a real negative impact on the competitive landscape, where the ability for new players to enter in the marketplace and create the very competition that I think so many of us would like to see in this space, it becomes tougher and tougher for those organizations or those companies to compete. Now, the response I know from some will be, well, listen, we can then establish specific rules for the very large companies and exempt from the rules some of the smaller ones. But of course, that then undermines the very notion that these are essential rules that will address an important public policy. If you're effectively explicitly excluding segments of the marketplace from those rules, either because they're companies that come from your own jurisdiction or because they happen to be smaller, well, of course, they may ultimately become larger companies, but I think that you, in many ways, discredit the argument that this is such an important policy issue that we have to make certain sacrifices, whether it's around freedom of expression or privacy or the like, but yet we only do it for quite literally a handful of companies. And so I don't think those rules have been well thought out, nor do I think that they were the result of the kind of open democratic policy process that we would like to see. And there's going to be, organizations are going to speak out, of course, on all sides, but it was frustrating to see the number of citizens that were speaking out very loudly against some of the European proposals, only to see them go ahead anyway.
I have another question for you regarding piracy blacklisting. And the start of my question, it is that in the latest years, several jurisdictions have engaged in a new strategy for fighting digital piracy on a global level, organizing lists of websites that systematically infringe copyright, allowing advertisers and partners to penalize them both contractually and economically. Sometimes that the literature has called this phenomenon of marking and selecting website as piracy blacklisting. So the most prominent example that we selected for illustrated our question is that it seems that the recent example of WIPO's BRIP database, which is fed by the data from the UN member states, is a good example to illustrate what is piracy blacklisting and what would be this trend regarding this act of marking, selecting, and exposing websites as websites that promote or do piracy regarding copyright. So critics, in one hand, pointed out that piracy blacklisting is a flawed strategy. and advocate for tougher transparency and due process requirement to include these websites in blacklisting. And you mentioned in one of the answers that you provided to us that this idea of due process and more transparency, it's very important when we are thinking about an approach regarding copyright issues, especially, and you mentioned for notes and takedown initiatives. But do you think that, and this is my questions, do you think that piracy blacklisting is a good strategy? What is your opinion regarding that kind of approach?
Yeah, so we had an extensive policy debate around this issue as well. And we've tended to describe it in terms of website blocking, but it obviously involves the notion of identifying sites that that rights holders will argue should be blocked. And I've been an opponent of that policy for a number of reasons. One is that I think our experience, the experience around the world when it comes to website blocking is invariably one of overblocking, where sites themselves, it sounds easy to identify what are viewed as sites that ought to be blocked. The reality is it is not. And that invariably the experience in country after country after country is that where you engage in mandated website blocking, you will capture not only the sites that you intend to capture, but you will capture other sites along the way. And so that impact on freedom of expression, I think is a real problem. I think that there are questions around the effectiveness of the strategy as well. There's any number of different approaches that can be used: domain name blocking, IP address blocking, sometimes for images, image-specific blocking. So there's a number of different technological approaches that are used. The reality is that very often users can find ways to circumvent or get around some of those technologies in any event. And so they are, the effectiveness, I think, is open to question. I think the effectiveness is also open to question because I think frankly, the more foundational debate about the source of piracy or the reason for piracy or unauthorized infringing activity. And so I think we've had now at least 2 decades in the internet context, and even more if we go back to earlier days, where the argument was if only we had stronger laws, or if only we used some of these technological measures, people would stop infringing. And I think the experience has consistently been that the #1 way to get people to stop infringing, stop engaging in piracy, is competing in the marketplace with well-priced, user-friendly alternatives. Essentially, it's a market issue more than it is a legal issue. And so, I can think back certainly to the days of Napster on the music side when people thought the industry will no longer exist. And of course, now we have services like Spotify and many others, and Apple, of course, that first moved into paid downloads. And for many, the fact that there is a convenient service that's reasonably priced that offers up the equivalent, if not better, access has meant that people are quite happy to pay, and the piracy issues have disappeared for hundreds of millions of people, largely because there is a competitive alternative. And the debate is instead about how much are artists being paid out of those services, as opposed to a debate as to about individuals engaging in infringing activity. The same is true on the video side, of course, where initially there was all kinds of accessing streaming services and downloading different sorts of video content, and then along came services like Netflix and just the myriad of other streaming services. And once again, we had convenient, well-priced alternatives available in the marketplace, and consumers by the hundreds of millions began to pay for this content. And to the extent to which we still see at times some of the infringing activity, in many instances, it is a function of the lack of availability of a particular form of content, where the rights holder is, of course, entitled to make a choice about what's in or what's out. But the fact that some of this is not Otherwise, when content is not available, it's a choice that gets made, but the risk is, of course, people want to pay for it. If you make it hard for people to pay for your content, we know sometimes what will take place. So I think the answer is frankly competing far more than it is some of these legal rules. And in particular, I think that moving towards blacklists raises the concerns that I just mentioned, amongst others. We could have also talked about net neutrality issues, the lack of transparency in terms of what is taken down, the lack of accountability after the fact for what gets taken down, oftentimes the lack of an appellate process associated with takedown. So there are just so many issues that are implicated by this, and the risks and the harms associated with it, I think our experience shows us are very real.
And my final question for this interview is, what advice would you give to Brazilian authorities when thinking about considering a copyright reform? What would be a good advice if we starting to discuss what would be a good copyright regime for a digital society?
Yeah, no, that's a great question, and in some ways it's easier to talk about what not to do rather than what to do. I guess I would highlight at least a few points. The first is that I think it's open to each country to make their own choices within the broad international framing of things like Berne. And so, notwithstanding the pressure that comes from rights holders and sometimes from countries speaking on behalf of rights holders, the reality is countries ought to be thinking about their own national interest. And that applies, I think, broadly within intellectual property. We've seen it play out in the debate around patents and vaccines. And I think we see it play out in a copyright context as well. Policymakers need to recognize that where choices are being made and pressure is coming from external sources, oftentimes it's because it's in their interests to engage in that pressure, and money out of the country, consumers paying more for cultural products, sometimes is great if your local artists are benefiting, but oftentimes it's not the case. I think policymakers need to be very attuned to who is speaking as part of this debate. And that applies both in the context of creators, where oftentimes it is large intermediaries that purport to speak on their behalf, and oftentimes I don't think represent their best interests or their interests. And I think we've seen more and more creators speak out in that context. And I think as well, the broader public, whether the education community or users more broadly or innovative services, are important stakeholders as part of this. And they need to be heard. I think that needs to be a recognition that there is room to be innovative. And so when I think of the Canadian experience, some of the best parts about it was a willingness of the government to say, it's okay if other countries haven't adopted this approach. Notice would be an example. A specific exception we have for user-generated, non-commercial user-generated content would be another. Another one that we have for sites that really play a key role in creating piracy or facilitating piracy, enabling piracy is the term used in the statute, is another innovative approach. And so it's not just about flexibility, it's about the totality of saying that there is room to be innovative in this space. And I guess lastly, it's to recognize that policies that are made are difficult to undo. It takes time for the market to adapt, and then it takes a very long time if you make a mistake on some of these issues. And so, as we move towards a world where there is more innovation and the need for more flexibility, making choices today that reflect business models today that can have really a limiting impact on some of that innovation, run risks of having a negative impact for many, many years and are very difficult to undo. And so in certain respects, one of the approaches needs to be a do no harm approach. Identify and recognize some of the risks and the harms that can come from certain policies, because choices you make around some of those policies are the kinds of choices that you're going to be left with typically for a pretty long period of time.
Thank you very much for this interview, Professor. We had a wonderful discussion here. a lot of your answers will help us to reflect and discuss these subjects in Brazil. So thank you very much to be a part of the project. And thank you, I'm thanking our audience as well. Thank you for watching, and see you next time for the next interview in the copyright project here at FGV. Thank you.
Awesome. Thank you very much.